Hello everyone, welcome to JIIB CIB Prep. In today's video, we'll discuss about unit number 30, contract of indemnity. So in this particular unit, we'll understand what is a contract of indemnity, how is it different from contract of guarantee, what are the rights of an indemnity holder, what is an implied indemnity, is section 124 of the Indian Contract Act exhaustive or not, how is it applied with respect to bank. We'll check your progress and we'll do some practice questions. So without further ado, let's start today's class. So what is indemnity? This particular word indemnity means to protect someone from loss or to save someone from harm or damage. In law, a contract of indemnity is an agreement where one person promises to compensate the other for the loss. And this loss may be caused by the person making the promise or by someone else. So it is a contingent contract, which means the promise is only carried out if a certain event happens or does not happen. Until the event occurs, there is no obligation to pay. For example, suppose I say to you that if a particular person X sues you for a particular amount, say 20,000 rupees, I'll pay you for any loss you suffer. Now, here I the person who is giving the promise is known as indemnifier. The person who's getting protected is known as indemnified or indemnity holder, and if that particular person X sues you and you suffer a loss, I compensate you. Now, which section of Indian Contract Act defines the contract of indemnity? It is section 124. Section 124 states that a contract by which one party promises to save the other from loss caused by the conduct of the promisor himself or by the conduct of any other person is called a contract of indemnity. Now, who is the promisor? In that particular example, I am the promisor. I am promising you to save from the loss. So, I am the promisor and you are the promisee, the indemnity holder. Now, this definition covers only one type of indemnity where the loss is caused by a person's conduct. But courts have expanded this meaning through judgments, applying fairness and common law principles. There's a particular case law, Secretary of State versus Bank of India. Let's dwell into it. So here, Mrs. G owned government promissory notes and she gave it to her broker, Mr. A. Mr. A forged her signature and sold it to a bank. The bank, thinking everything was fine, got the note transferred in its name by the government public debt office. Later, Mrs. G found out and sued the government. She won the case and got the compensation. Now, the government, in turn, sued the bank to recover the loss. And the court held that the bank must indemnify, meaning to say compensate the government, even though the bank never directly promised to do so, because common law imposes such liability when someone's act causes loss to another. Now, insurance contracts are example of indemnity contracts. So, most insurance contracts are indemnity contracts. For example, a shopkeeper buys fire insurance for his warehouse, and if the warehouse catches fire, naturally the insurance company will pay the shopkeeper for his loss according to the policy and terms, of course, but only if the event actually happens. If fire happens, then only the insurance company will pay. And secondly, for the insurance, the shopkeeper has to pay the premium. And if both of these conditions are met, then only the insurance company will indemnify the shopkeeper for his actual loss. Now, how is it different from a contract of guarantee? We'll discuss contract of guarantee in our next unit, unit number 31. And in unit number 33, we'll understand a type of guarantee, deferred payment guarantee. But it is important for us to know how these two contracts are different, because in contract of guarantee a person also guarantees to save another person from the loss, but here the number of parties in a contract of indemnity are two: indemnifier and indemnified. So it is you and me. You are the indemnified and I am the indemnifier. I'll promise to save you from the loss. In guarantee there are three parties: debtor, creditor and surety. Now let's take an example. For example, a person A approaches the bank for loan. Now in this particular case, bank asks A if someone else gives a guarantee on your behalf. So A approaches you. You, my dear friend, can you guarantee that I'll pay my bank loan? You know, Mr. A, he pays money on time. He has a good financial record. So you guarantees that if A defaults, I'll pay. So if A does not pay, bank will catch you. Bank will ask you to pay. Now in this particular case, bank is the creditor, Mr. A is the debtor, and you are the surety. You are saying that I am giving the guarantee, so you are the surety. So here three parties are involved. With respect to risk in indemnity, there is a contingent risk that it will arise only if the event happens or event does not happens. But in guarantee, the risk is subsisting. Liability is continuous. Nature of liability in indemnifier's liability starts as soon as the loss occurs. In contract of guarantee, surety's liability is secondary and debtor is the primary liable for paying the loan amount. With respect to contracts, number of contracts, there is only one contract between indemnifier and indemnified, and in a contract of guarantee, there are three contracts. One with respect to debtor creditor, second creditor and surety, and third surety and debtor. So, if you pay on Mr. A's behalf, Mr. A automatically becomes liable to pay you the money. Now, the purpose for contract of indemnity is to reimburse actual loss, and in contract of guarantee, it is to assure creditor about repayment or security. With respect to form, a contract of indemnity can be express, meaning to say the words are written or spoken, or implied, meaning to say based on conduct. Whereas in guarantee, it is generally express. With respect to coverage, in contract of indemnity, only actual loss caused by the specified event is covered, but in contract of guarantee, it may cover the full debt or obligation of the defaulter, the debtor. Now, there are two forms of indemnity. Before proceeding to rights of an indemnity holder, let's understand these two forms: express indemnity and implied indemnity. So, express indemnity is a written contract where a person promises another person. So, if your goods are damaged during transport, I'll pay for the loss. So this is an example of express indemnity. And implied indemnity, so the case law which we have just discussed here, Secretary of State versus Bank of India. So this is an example of implied indemnity. Let's now move on to the rights of indemnity holder. So, according to Section 125, if the indemnity holder is sued because of a matter is covered in the indemnity and he is acting within his rights, so he can claim from the indemnifier the damages paid in the suit. So, if the indemnity holder has to pay money as damages in a court case, he can recover the entire amount from the indemnifier. Then he can also recover the cost of the suit. So indemnity holder can also recover the legal cost of defending the suit, such as lawyer fees, court fees, and related expenses, but only if he did not go against the indemnifier's instruction. He acted wisely as a reasonable person would, and the indemnifier had authorized him to bring or defend the suit. And thirdly, amount paid in a compromise in a settlement can be recovered. So if the indemnity holder settles the case outside the court, he compromised by paying money. So he can claim this amount from the indemnifier if the settlement was not against the indemnifier's order, if it was reasonable to settle even without an indemnity, and the indemnifier authorized the settlement. Specific performance. So there is a right to specific performance if the indemnity holder has already incurred an absolute liability, a confirmed obligation to pay, and the indemnity covers it. He can go to the court to force the indemnifier to honor the promise. Uh, but again, there are some conditions. There are some two factors to claim these rights. Number one, the indemnity holder must act within his scope of authority, and he must not break any specific instruction to the indemnifier. Uh, The factors which affect the claim are the damages, the cost, and settlement amount. So, with respect to damages, the code differ on when the indemnifier's liability starts. Some say it starts only after the indemnity holder has actually paid. Others says it can start earlier when the loss becomes certain. So, the preferred view is that it starts when the actual loss is when the loss is actually suffered. Secondly, the cost. Only reasonable cost can be claimed, like legal fees, travel expenses for the case. And with respect to settlement amount, settlements must be genuine without fraud or collusion and not against the indemnifier's instruction. Implied indemnity. So even if there is no written contract, sometimes the law implies one from the circumstances. If a person does something at someone else's request and it turns out to harm a third party, even though the doer did not know it was harmful, the person who made the request must indemnify. So that particular case is an example of implied indemnity. Enforceability of a contract of indemnity. So the indemnifier's liability starts as soon as the loss of the indemnity holders becomes certain or imminent, even if he has not paid anything. So if a bank knows that a court has already ordered payment against its customer, the indemnifier's liability can start even before the bank actually pays, because the loss is definite. It is uh, imminent. Now, scope and application of indemnity contract to banks. What is the use of indemnity? In banks, in banking, indemnities are very common. So, some of the examples include lost demand draft or traveler's check. So, customer must give an indemnity before getting a duplicate. So, the bank is protected if someone later presents the original. If bank issues duplicate fixed deposit receipt, so customer signs an indemnity bond. So, the bank can recover the money if the original is misused. And in death claim settlements, before paying legal heirs, banks may take an indemnity to protect against later claims from other heirs. Banks may also ask for extra surety if the amount is big or if they don't know the customer well. And indemnity bonds are usually stamped as agreement, but if witnessed, they may be treated as bonds and attracts higher stamp duty. So let's check your progress now. A person promising to save another from loss is called indemnifier. B is the correct answer for this question. There are dash parties to a contract of indemnity. So there are two parties to the contract of indemnity. Indemnifier's liability in a contract of indemnity, it is primary. So A is the correct answer. Which of the following statement is or are true? There are three parties to a contract of indemnity. No, there are two parties. So this statement is not correct. Indemnifiers liability occur only if indemnity holders suffer loss. So this statement is true. Customers, as a matter of right and without an indemnity, can obtain duplicate demand draft. No, they must give an indemnity. Indemnities are required by bank purely as formality and does not serve any other purpose. So this statement is also not correct. So B, only 2 is correct answer for this question. Now let's do some practice questions. Which of the following statements are correct regarding a contract of indemnity under the Indian Contract Act 1872? A contract of indemnity is a contingent contract dependent upon the happening or non-happening of an event. So this statement is correct. All type of indemnity contracts, uh, all type of indemnity contracts are fully and exhaustively covered under Section 124 of the Indian Contract Act. No, this statement is not correct. The person who promises to indemnify is called the indemnifier. Correct. Insurance contracts are example of contract of indemnity even though they are not dealt under Section 124. So this statement is also correct. As per law, indemnity holder must prove an actual loss to claim indemnification. So yeah, the indemnity holder must prove a loss before claiming. So this statement is also correct. So 1, 3, 4 and 5 are correct, making option C as the correct answer for this question. Consider the following statements about contract of indemnity and guarantee. A contract of indemnity always involves three parties. No, it involves two, so not correct. Contract of guarantee involves three. In a guarantee, the creditor is primarily liable to make good the loss. So it is the debtor who is liable, not the creditor. So this statement is not correct. In an indemnity, the indemnifier must compensate for the loss as soon as it occurs. So this statement is correct. A contract of guarantee involves at least three separate contracts. Correct. Contract of indemnity may be express of or implied. Again, correct. So 3, 4 and 5 are correct, making option B as the correct answer for this question. Consider the following statements regarding the right of an indemnity holder under Section 125 of the Indian Contract Act. The indemnity holder can recover all damages he may be compelled to pay in a suit. So this statement is correct. He can recover cost only if he acted against the specific instruction of the indemnifier. So this is not correct. Not against, he should act in line with the instructions. Sums paid under a compromise can be recovered if it was authorized or prudent and not against the promiser's direction. This statement is absolutely correct. The indemnity holder is entitled to sue for specific performance if he incurs an absolute liability under the contract. Again, this statement is correct. All costs, whether reasonable or not, so only reasonable are recoverable, not unreasonable, making this statement incorrect. Courts differ on whether indemnifier's liability start before or after the indemnity holder incurs actual loss. So this statement is actually correct. So 1, 3, 4 and 6 are correct, making option A as the correct answer for this question. Consider the following statement regarding the contract of indemnity. A contract of indemnity under Indian laws can arise by implication from the conduct and circumstances of the parties. Yes, this statement is correct. The liability of the indemnifier arises only after indemnified has actually paid for the loss. So this is not correct. Indemnifier's liability does not require the indemnified to pay the loss first. So this statement is not correct. Under Indian law, the indemnifier's liability begin when the indemnified loss become absolute or imminent, even if not yet paid. So this statement is correct. So statement 1 and 3 are correct, making option C as the correct answer for this question. Consider the following statements regarding indemnity contracts in banking. Indemnities are taken by banks before issuing duplicate instruments like demand draft and traveler's checks. So this statement is correct. When indemnities are witnessed, they are treated as indemnity bonds and attract ad valorem stamp duty. Again, this statement is correct. Banks never require a surety along with indemnity, so this statement is not correct. Banks may require surety in addition to indemnity. So statement 1 and 2 are correct, making option A as the correct answer for this question. So this is it for today's class. I hope everything is clear to you, but again, if there are any doubts, please don't hesitate to ask them on our Telegram group channel, JIB CIB Prep. We'll meet again with unit number 31, contract of guarantee. Till then, please take care.